some stuff happened at the end where his lawyer accidentally gave a whole bunch of text messages, pretty much gave the contents of his cell phone.
By email?
By email or some sort of electronic delivery system. Gave a whole bunch of cell phone contents with text messages related to a number of other subjects. Some of them relevant to statements that could potentially cause him to be found guilty of perjury. And I'm seeing that word tossed around. So, and this is an interesting thing too, because we were talking about the difference between criminal and civil actions. So one of his problems right now could potentially be, and you can talk a little bit because you've been reading this article, you can talk a little bit about how he got them or whatever and what's in it, but and what that means. But if you lie under oath, then it can go from a civil suit to a criminal suit.
The lawyer defending conspiracy theorist Alex Jones in a Texas trial drew his own national headlines this week for accidentally handing over highly sensitive data to his adversaries, opening him up to potential legal consequences. Houston lawyer, whatever, acknowledged that Jones' legal team had provided lawyers for the parents of children killed in the Sandy Hook Elementary School mass shooting with digital copy of the Infowars finder's phone's contents, which include text messages and medical records. Okay, so here's the thing. I can't tell how it went over. But if it's by email, it can happen by accident. Mm-hmm. You email lawyers on the other side, 8 million parties, it's in your cache, accidentally you didn't notice and it went over.
Well, you were telling me earlier that there's a difference in the way that Canadian lawyers would handle such a situation versus what seems to have happened here.
I'm not going to give evidence or opinion on behalf of everybody, but my experience has been if we divulge information by accident that the other party knows was by accident, they respond by, I've received certain information that I know was sent by accident. We're going to delete it.
So then, except for if, because when you say turn over all of your emails and so on, and somebody says, this is it, you don't know if they're lying about whether that's all the emails they have. So if you accidentally turn over emails that show that you lied about, you were actually concealing evidence that you were told to turn over, that's a different story.
Great point, Diana.
Thank you. I'm learning.
You're ahead of the game. Okay, so let's break this down. Well, let's say you're an idiot and you turn over by email text messages that show that your client's a f***ing asshole.
Well, but are you an idiot or are you just complying with the subpoena?
Okay. You send an email that accidentally has confidential emails or text messages that are crucial to the litigation. Normally in Canada, that's part of your discovery. In other words, when you're suing each other, relevant information in your possession should be disclosed, unless there's some overriding privilege. If it is given by accident, the lawyer might say on the other side, you gave this to me by accident, I realize that, I'm deleting it. But if it breaches what your obligation was, they would say the following. You've disclosed to me by accident the following email. I can tell it was by accident. That said, it's crucial and should have been disclosed to me through documentary discovery. I'm going to seal it and seek an order from a judge so that I can have it.